So in this hour, we will be covering the constitutional treaty, so the last phase of the integration. I'm not saying the last phase, obviously, it's not the final phase. The EU is an evolving project. And at the same time, that's why the whole EU process and the EU integration is considered as a moving and changing process. And what we say today will not be the EU that we will be seeing in 10 years down the line or 5 years down the line, because it's constantly changing and evolving. And with the constitutional treaty, a new step has been added. The origins of the need for the constitutional treaty goes back actually till the Treaty of the European Union, this pillar structure, the introduction of the pillar structure. The introduction of the pillar structure was hoped to solve the problems of the functioning of the EU. It was considered as a revolutionary process, and it's going to be making the EU function more effectively and efficiently. But it's been shown that because of the complicated pillar structure, certain policies are held in different pillars, and the competences of the member states and the EU is being divided in a certain manner that it made it very difficult for the EU to function. And that's why with the Amsterdam Treaty, this complicated structure was aimed to be simplified and become more effective, and with the introduction of certain other provisions, the policy areas were hoped to become more effective. For example, there are certain issues which were under the Justice and Home Affairs pillar that were moved towards the Community pillar with the Amsterdam Treaty, because it was thought that, like in the case of certain issues regarding migration, refugees, asylum, it's not possible to decide at the intergovernmental level, that it has to be decided at the supranational level, so at the community level. So the cooperation has to be more advanced. So that's why some of the subject matters were actually moved from the third pillar to the first pillar with the Amsterdam Treaty. As you might possibly imagine, this made the whole functioning of the EU a bit more complicated. So that's why the Nice Treaty, by the way, you were right, it's 2001. The Nice Treaty was also hoping to simplify the already complicated policies, procedures, and also the article structures. And 2001 not necessarily solved that issue. That's why it was necessary just after the Nice Treaty to start a new process of a convention in a way to bring all the EU member states together and also the candidate member states together to discuss the future of Europe, what kind of a Europe we want. That was openly discussed. So it happened just after the Nice Treaty. So the Nice Treaty was also not an answer for the future enlargement of the EU and the better and effective functioning of the EU. That's why we see the Lisbon Treaty and the Constitutional Treaty. And now we're going to focus on the Lisbon Treaty, how things develop towards the Constitutional Treaty, and why the Constitutional Treaty couldn't come into being, why it couldn't function, and why it failed. And that's why we had to have a Lisbon Treaty, which is now in force. As I said, the Nice Treaty in 2001 was accepted, and then later it came into force. After it came into force, an immediate process started. 2004 enlargement was very close by, and this treaty wasn't a solution of the necessary changes that was going to make the EU more efficient, more democratic, and at the same time, in terms of the decision-making process, more egalitarian. And the member states thought that this time, compared to the previous times, we should start a new process. Like the US Constitution was first established with a convention that it was openly discussed and was openly accepted by the public, by the ordinary citizens. It was aimed at the same kind of procedure should be started. And we see the Laeken Declaration. The Laeken Declaration came into being in 2001 on 15th of December. But the Laeken Declaration, after the Laeken Summit, it was aimed at there was going to be a convention process started. The convention process was going to include, it was a very egalitarian in that sense, an equal ground for both member states and the candidate countries to come together. And they were openly going to discuss about the future of the EU, what kind of a EU they would like to see in the future, what kind of roles the EU should have, what kind of a treaty framework that the EU should adopt, and at the same time, what kind of policy areas should be more developed than the others. That was the aim. And the decision-making procedures and the role of the EU in the world, the global, the actor role of the EU in the world, and the symbolic values as well. So is it going to be more intergovernmental? Is it going to be more supranational? What kind of roles the EU should be discussed openly. They also wanted to have not only the government officials, but also the ordinary public, the people on the streets, the young people. So the youth councils should be invited, they thought. NGOs should be invited. So different kind of opinions should be presented in this convention. Politicians should be there, which are not only from the governing parties, but also the opposition parties' members should be included. And the candidate countries should be included as well. This was done in the European Parliament in Brussels. Turkey was also included as a candidate country in 2001. The first plenary session happened in 2002 in the European Parliament in Brussels. The members of the parliament, each member of the governing party and opposition party member was included. At that time, Turkey was run by a coalition government in 2001. So DSP, the left-wing party, MHP, DYP, and ANAP, the four parties that were represented in the first European Convention. In addition to that, they included NGO representatives were able to present their views. The youth councils didn't exist in Turkey at that time. There was no national youth council in Turkey. So what happens is that they ask for the national parties to present somebody. And there was also somebody from representing the Turkish youth in Europe. Somebody from Germany, a law student from Germany, was a Turkish origin law student from Germany, was also present and represented Turkey in the Youth Convention. So it was called the Senior Convention, and it was called the Convention for the Future of Europe. The Convention for the Future of Europe. If you Google it, you will be able to get more information about it. The aim was that with the end of this convention, and conventions usually happen over time, in a long period of time, 1 year, 2 years. And at the end of these discussions, these plenary sessions, you usually will adopt a legal document, a text that's going to be valid. It's usually the case, for example, the UN Declaration of Human Rights, the same thing, Universal Declaration of Human Rights, or the European Convention for Human Rights, usually accepted through these long period of time of different member states coming together and discussing certain articles and coming up with a general statement. That was a similar aim. So the Convention for the Future of Europe was hoped to create a text, a legal document that's going to be representing kind of a constitution in the sense, a legal text, a declaration that will be simple, easy to understand for the citizens of Europe, and also easy to implement. So the whole complicated procedures, which were like hundreds and thousands of pages that were in place, and it was very difficult for the EU citizen to be able to understand how the EU is actually functioning, will be simplified. That was the aim. And this was done in a convention including people of Europe, including the citizens of Europe, that it's going to be a product of the citizens. So it's going to be widely accepted. Not only the enlargement was the reason for this need. The other reason for this was there was an increasing criticism towards the EU. The EU is becoming more bureaucratic, the EU is becoming more distant from the citizens. it's very difficult to understand what is happening in Brussels and the Brussels institutions. If you want to understand a single text, you have to read through hundreds of pages of legal documents, and you wouldn't be able to understand. Even if you're an EU law expert, it was difficult to understand, yet alone you're an ordinary citizen. And keep in mind that in order to create legitimacy, states have to have a social contract. This social contract is usually the constitution. In the constitution, you will know your rights and your duties. And constitutions in general in the world, if they're well written and well prepared, should be simple and clear-cut and not necessarily very long and technical. It should just frame the general rules, the duties and the rights of the citizens, and it's a contract between the state and the citizen. Similar kind of understanding was valid here. So they were hoping that to prepare a document that is simple and easy to understand. You don't necessarily have to be a EU legal expert to be able to understand this, and you can actually understand how the EU functions and what the EU does for you, basically. So increasing legitimacy, increasing support, the public support for the EU, but at the same time trying to put the EU in a place that for the future of the EU, this has been discussed by the citizens and involving the citizens. So this elite project, as it's been criticized, this elite project becomes a more democratic project. And the discussions about democratic deficit, which we will discuss, being argued that the Brussels bureaucracy was taking over the EU. So people who are not necessarily representing the people of Europe are actually running their countries for the EU. And as the EU has supranational characteristics, it becomes a problem. So making this a part of a more democratic and equal process, the EU was trying to legitimize itself as well. So trying to gain a more supported understanding for what it is in terms of its functioning, in terms of decision making. So this treaty process served various purposes. It served this legitimacy purpose, it tried to involve the public, tried to get the support of the public for the future, at the same time simplify the procedures and try to become more effective and efficient. It was serving various purposes all at the same time. The idea was good, involving both candidate countries and the member states. And Turkey, for the first time in its life at that time, was represented as the equal ground. So you could actually present an idea or opinion, or you can bring an opinion in the plenary session, and you can make it discussed, basically. I mean, the candidate countries didn't have the right to accept the final text, but they could have brought issues. In parallel to the senior convention, as it was called, they also made a youth convention. And in the youth convention was a similar thing, different issues were being discussed, and at the end of the youth convention, a final text has been approved by representatives from all candidate countries and member countries, and Turkey was also part of it. And I was luckily part of this youth convention as well. I was also representing Turkey in this youth convention. It was an interesting process. We adopted an incredibly, I think, federal and supranational text, which was not really represented in the final text, obviously, because we were suggesting that there should be there should be an EU capital city, this and that. We were incredibly federalist in terms of our understanding of the future of the EU, which was not presented at the end. But at the end of the day, it was an interesting experiment. I'm calling it an experiment because the final text was being finalized and approved, and it was presented in the member states. The other issue that I have to mention about the constitutional treaty is that the name constitutional. It was a constitutional treaty. In short, you might see it in different places as CT. The name is important because there was the name constitutional in it. Why it was necessary to mention that it was a constitutional treaty? Because there was already constitutionalism within the EU. The treaties and the legal structure and the EU law and the European Court of Justice decisions, the cases, was already bringing constitutional elements. What does that mean? As I mentioned earlier, a constitution outlines the rights and the duties of the citizens and the governing structure. The EU didn't have something like this. The EU didn't have a list of rights saying that the EU citizens have this as a right, and in return the EU has this as a duty. There was no such a legal document. But already there were certain rights for the EU citizens that were already in place, and they were already being protected by the EU law. And they were already being protected by the European Court of Justice. So there was constitutionalism in that sense without having a constitution. This created a gap, a problem within the EU law structure itself. So having a list of those rights would have a symbolic value in the sense that it will put in place the rights, which were not any different than any kind of rights that were already being accepted by the constitutions of the member states. They're already in place. Also, the other international legal documents that the EU already been accepted, the EU member states already been accepted, for example, the Universal Declaration of Human Rights or the European Convention for Human Rights were already in place, but it will give a symbolic value to the EU. It will increase the legitimacy of the EU. It will give a symbolic value for the world as well, that the EU actually can declare those rights for its own citizens. If you would like to become a global power in the world, and if you want to promote a soft power policy, and if you want to promote human rights, democracy, freedom of expression, and try to export these values and ideas all around the world, you have to do the same thing at home. If you cannot do these things at home, you're not going to be a legitimate power to be able to export those ideas abroad. That's why the EU wanted to have a list of those rights being incorporated into its legal and treaty structure. Any ideas what those rights were called? There was a list of rights. Charter of Fundamental Rights. Temel Haklar Şartı in Turkish. That was a list of rights. And to have dignity, the basic human rights basically, nothing too complicated in that sense. And nothing necessarily new. But there was a list of rights that the EU was declaring that every EU member state who's actually a part of this treaty structure and part of the EU will be obliged to protect, and they have to keep it into action. So that was the aim. That made it, this list of rights also made this treaty a constitutional treaty in terms of, from a legal point of view. Temel Haklar Şartı, THŞ ne demek diye soranlar için. Temel Haklar Şartı in Turkish. Yeah. İçinde, başlangıcında. Preamble, like a preamble, it was starting with a Charter of Fundamental Rights. It was in the beginning, there was a preamble, like these are the rights for the EU citizens. Next class, I can bring you the charter itself. It's not as impressive as it sounds. It's a tiny little booklet that the European Commission printed, or the European Parliament, I think, printed. It's a tiny little booklet. But the whole idea was symbolic. So it was in the beginning, it was giving the constitutional character to the constitutional treaty. So the head of the whole convention was Valéry Giscard d'Estaing. He was French, he was a very old politician, an ex-president of France. Some people argue that it was symbolically ironical in the sense that somebody who's really old was actually trying to present the future of Europe. But at the end of the end of the convention adopted a text that was adopted later on by the Council, the European Council. And after the European Council accepted this text, it has to be accepted in every single member state by a referendum. What happened is that's why it's ironical, in France it was rejected. It was a whole project of France as well, this whole the convention issue. It was very in a supranational system. It was trying to push for more integration. France was the engine of integration. France was always pro-integration, always supporting further integration, deepening. And at the end, in France, it was rejected. And later on, in Netherlands, which is also a founding member state of the European Union, it was rejected again. French said no. Dutch said no. And then the whole process stopped. Wait a minute. The reason why it started with France was that it was hoped that it's going to be accepted in France and then Netherlands. And more skeptical countries, for example, UK, when by the time that it's time for a referendum in the UK, it would be accepted by many countries, so it would be easier for the UK citizens to push for a more of a yes vote. But when it was first presented to France and Netherlands and no, then it was a big question mark. And it made the politicians think again. So what happened is that they start questioning why it's been rejected. Some people, although being benefited very much from the whole EU integration process, I mean, when you look at it, we're talking about 2004, there has been no wars in the European continent. So there's been peace, stability, prosperity. So there are successful processes that's going on, lots of policies were in place, and somehow people are still feeling alienated from the whole process. And despite the whole efforts for the Convention for the Future of Europe, trying to involve the young people, trying to involve NGOs, trying to involve non-governmental actors, government, opposition, candidate countries, member countries, trying to make this process as democratic as possible, somehow there's still some kind of an alienation between the EU citizens and the whole EU process. So that's why they had to come together and start thinking about the process. And the name constitutional, apparently, was problematic. Some of the citizens were afraid that the nation state status of the member states would be lost, so that they're becoming more federal. And not everybody was quite happy or comfortable with the idea of a federal Europe. It might, Constitutional Treaty was not necessarily bringing big changes, but symbolically that name change was critical. So that's why certain treaty provisions that has been problematic and brought certain tension points in different member states were removed and changed with the Lisbon Treaty compared to the Constitutional Treaty. And the name was also changed. So the name becomes Lisbon Treaty because it was accepted at Lisbon, Portuguese capital. So the name becomes Lisbon Treaty. And the Charter of Fundamental Rights, which was in the beginning of the treaty, which was presenting a more constitutional characteristics, was moved as an annex. So it was put on the back. It was an annex of the treaty. Nothing has necessarily changed in the content of the Charter of Fundamental Rights, but it was moved on the back. So it became an annex instead of the preamble. And it was presented again to be voted. As you know, when the Lisbon Treaty was presented in Ireland, it was rejected. The first referendum in Ireland was very close, but still it was a no. Then it was again a question mark. So what are we going to do? is this the end of the whole EU integration process? Like, we are trying to move forward. This is something actually good for the EU, for the citizens, and a country like Ireland, who benefited a lot from the EU integration process in terms of finances, in terms of economic development, in terms of political stability. It had a bigger say in the world. Being part of the EU can say no to something that is going to be very beneficial for themselves as well. Then we have to think twice. I mean, there are certain issues that some people argue that even with the attempts to make it very simple, it still was very complicated. Nobody actually read it. It was a very long, legal text. Like, if you ask somebody on the street who voted no, if you go and ask them, they said, no, I didn't read it. But because I heard that there is an article about this, that's why I said no. There were issues regarding the foreign policy and defense policy that the Irish people felt very uncomfortable. Some of the reasons was that. Abortion issue was another issue that the Catholic Irish people didn't feel comfortable. Apparently another issue was regarding that. Losing independence, being a small country but getting lost in the whole big EU process was another issue that they didn't feel confident about. And simply maybe bad luck, because usually the political processes are like that. I mean, sometimes you cannot go into very deep analysis about certain issues, and maybe it wasn't known very well. Maybe the yes vote didn't really push it very hard. The no vote was more visible. I mean, the ads were more visible in the news, and sometimes it's very easy to popularize certain topics like abortion, and it can be overshadow the whole issue about EU integration. Future stability of Europe becomes an issue about abortion. Sometimes it's as simple as that. Anyways, there was a second round of referendum, and finally, in that round, a yes vote came. And from 2007 to 2009, finally, in 2009, the Lisbon Treaty was accepted. Now it's in force, and it brought certain changes in the institutional structure, in the decision-making structure, in the voting structure. It tried to make the EU work more efficiently, more effectively, and try to close the democratic deficit that's been put forward and the EU has been criticized for so long in the last couple of decades. So it was hoping to make those issues much better, trying to simplify the legal text and at the same time, it abolished the pillar structure. There is no longer pillar structure in the EU. So that was also abolished. That's what I mean, it became more simplified, which was more fundamental in terms of changes compared to the Amsterdam Treaty and the Nice Treaty. That was what brought the Lisbon Treaty in place. So if you look at the issues that came into being, why people said no, the Irish no reasons for rejection. If I can quote from here, from the Michel Cheney book in chapter 4, there is a chart that you can have a look, and it says that, for example, the reasons why they said no, the major reason, any mention of information, knowledge, and understanding. So lack of information, knowledge, and understanding, treaty is too complex. People couldn't understand it. They didn't read it, but when they tried to read it, it was too complex and it was difficult to understand. So it wasn't very simple. And any other reason about the whole attitudes about the referendum process, loss of power or domination by large countries, or loss of power, independence, or identity. So they were afraid that they were going to lose their power and identity. And as a smaller country, that's why I mentioned that there's smaller country versus big country kind of differences, they were afraid that they were going to lose the identity of being Irish. Not everybody is very comfortable to become European in that sense. And the European Union, the EU is trying to promote a European identity, the EU citizenship. That's why we see these passports, which has they're all same. Even the Turkish ones are now red. We're already part of the EU, not being part of the EU. At least the passports are part of the EU. Red, so we are ready when we enter. We don't have to change our passports again. So it has the passports, which is symbolic value. And the Lisbon Treaty also brought issues such as the consular protection. So if you're in a non-EU member state, and your country does not necessarily have a consulate general or an embassy in that member state, and something happens and you need help, then you can actually go to another EU member state's embassy. So you're an EU citizen. You have a passport, you're an EU citizen, you have the protection of another EU member state. So those are maybe small, symbolic changes, but they're actually at the same time important changes that was brought by the Lisbon Treaty. And we will go into detail every issue we will be covering in the following weeks. There will be certain substantial changes in terms of the decision-making process, in terms of the voting process, in terms of how the institutions are actually functioning. There are different changes regarding the Lisbon Treaty that had implications on those different topic areas as well. Any questions regarding the Lisbon Treaty so far? And another thing that I have to add regarding the Lisbon Treaty is that this is not the end. I mean, this is not the end. There might be another treaty that is coming in the next 5 years, 10 years. As you can see, the whole treaty process, there has been treaties all along the EU's integration. And we will be looking in all of them. The Rome Treaty, the Single European Act, Treaty of the European Union, Amsterdam Treaty, Nice, and Lisbon. And there is one thing that I forgot to mention, I suddenly realized, naming the treaties. In 1957, when the European Economic Community was established, Euratom was also established. The European Atomic Energy Organization was also established. And over time, there was a merger treaty which merged all these organizations together as a merger treaty, 1970s. But the Euratom was also established, and like the coal and steel, another industry that was also quite critical in terms of war or peacekeeping. So Euratom was trying to make sure that the atomic energy was used for peaceful purposes in Europe, so that it's not going to be developed to produce warheads, which we might also question that who are the nuclear powers in Europe as well, not only in terms of nuclear power stations, but also with the nuclear missiles, the countries that have nuclear missiles in the world. But that's a separate issue. But it was also under the community framework. Any questions? No? Very clear.